Legally Speaking with me, Tarun Mangia. This is our special show with Dr. Abhishek Manu Singhvi, who, as you know, is eminent jurist, third-time sitting member of Parliament, also senior advocate. He's also served as the Additional Solicitor General of India. Today we're going to discuss with him on this program that we, as you all know, is titled Saturdays with Singhvi, which goes on his name. We're going to discuss Justice Chandrachud's, who's the Chief Justice of India, his judgment on the RBI's Master Circular of Fraud. Of course, he's now, in a sense, the judgment says that the businessman should get a hearing before the account is declared as fraud. Why this judgment is important, what are the takeaways, what are the implications, what are the implications on the business environment of India. So many people have suffered in the past few years because after the Master Circular came, was it an overreaction? All of this we'll get into. But first, let me welcome Dr. Abhishek Manu Singhvi.
Hello, Tarun. Thank you.
Thank you. As this show is titled Saturdays with Singhvi, this is known for your own special takedowns of the judgment, your own opinions, what you think about the judgment. First come first, I want to ask you, in about 3 to 4 minutes, 5 minutes, if you could explain, what do you think about this judgment?
Well, Tarun, I had the privilege of being the lead counsel for this, and I think it's a very seminal judgment. It was written, of course, when the present Chief Justice was the senior most number 2 judge, but not the Chief Justice. It has been delivered now. It was argued at that time. The first thing which struck me when I read about it in the papers was that the Chief Justice has rightly not allowed hard cases to make bad law. What does that mean? You know, fraud cases or alleged fraud cases where you are alleged to be guilty of a fraud in dealing with an account are always liable to create prejudice. They do always, as you know, all such cases involve lakhs of crores, thousands of crores. Figures are daunting, intimidating, and the job of the person who's the bank or the prosecutor is really to paint you black, saying, look, so many thousand crores, he's a fraudster. Where are all these niceties and good points of law meant for a fraudster like that? I think Justice Chandrachud's first point I want to make is his great achievement in this judgment is he didn't allow the hard facts of any fraud allegation case to become bad law. Otherwise, you allow these so-called prejudicial points to influence and you come out with bad law. Now, why do I say that he has done the right thing and right law? Not only because I argued it and we were successful. Please don't think that you can discount that fact entirely. There are 4 or 5 very path-breaking aspects of this. One, he develops the well-established doctrine and takes it to its logical conclusion. The real test is, does it have adverse civil consequences for the person concerned? That's first peg on which he hangs. And we can all discuss these pegs later if you like. The second is that they include consequences like civil death, making you a pariah, ostracizing you, not dealing with you, not settling with you, not giving you credit, etc., not restructuring your account. So in effect, it is all very well to say formally it is nothing, but actually it is everything. Substantively, it is civil death. Thirdly, I think he has applied rightly the principle that in effect these adverse civil consequences amount to blacklisting. The reason why the word blacklisting is important is because blacklisting necessarily brings in the concept of natural justice. The fourth peg of this judgment, which is important, is that policy decisions are not immune from challenges, including a challenge to the denial of natural justice. Yes, it's policy. Yes, you get a large latitude, but it doesn't mean that you just do the mantra of policy decision and natural justice or constitutional challenges get eliminated. The fifth aspect is that rightly it is underlined that Article 14 now includes natural justice, or rather natural justice has been elevated to the level of Article 14 some decades ago, some years ago. Earlier, it was a common law doctrine. Now it is made part of Article 14. So the learned bench really says that you are going to be in violation of Article 14 if you are able to do such things without natural justice. And then follows the logical conclusion that I, the judge, will read into this circular, the requirements of natural justice. And as we discuss it further, I'll have something to tell you about the doctrine of reading in, which is very important. Finally, the judge ends with another advance of the law. You must not only give notice, it's not a bare bones natural justice case. You must give a reasoned disposal. So I'm not here a formality. I call Tarun Nangia, I give him a notice, and then I just say dismissed. I must give reasons for the dismissal. It must be a representation considered and a hearing given. You may not have lawyers, but you must be heard. Then you must give reasons. So the whole thing has been worked out, fleshed out into a whole code. And, I think it's a great advance of the law, despite the supposed tag of bad boys or rogues against those who have master circular cases.
If we break down one by one, first, the point that you made, which was also argued, was tagging somebody as fraud means civil death or ostracizing. Could you just delve into that aspect a bit? Because the bank unilaterally does it without even informing the businessman in many cases.
To appreciate and analyze a case, it's sometimes useful to see the rival arguments or the arguments of the other side. In this case, the RBI or the banks. They made 2 or 3 interesting facets. They said, look, ultimately, this is a fraud circular, which means all that we are doing, and you must appreciate from their point of view, then you'll understand the finding. All that we are doing is, no doubt, characterizing Mr. Nangia as a fraud account, but it is only so that it is then sent on as information to the CBI or the ED or to the authorities, the agencies, who will then take action. They then linked it to another very important principle of law that, look, before filing an FIR, they said it's akin to the stage just before filing an FIR. And obviously, filing an FIR does not require natural justice. I don't have to give you a notice that, look, Mr. Nangia, I'm about to file an FIR against you. So they said this is that kind of process. And the whole idea is to catch you by surprise. It's a preventive measure so that banks are not gypped, society is protected, and the speed requires actual natural justice. So now you see the stark, contrast by which the argument is framed. In that context, the first principle Justice Chandrachud's judgment, the division bench's judgment uses, is that yes, formally what is there? Formally it appears in the formal facial sense that you're doing nothing. You are only characterizing Mr. Nangia as a fraud account and then sending intimation letters to CBI. But they went on to say, look, in effect, what happens? All the consequences which happen in a willful default case, where you admittedly have natural justice, by the way, all of them happen here and much, much, much more. They say that once you are declared a fraud account internally with or without natural justice, no bank will touch you. You are an outcast. You are financially untouchable. You are not going to get the slightest restructuring. They will not say that your account is expiring next month. We'll give you 1 month extra to pay with interest. You can't raise any other loan. Your entire companies come to a standstill. So they use the nice phrase, civil death, which is a phrase I had argued before them, that yes, you are alive, but in a corporate sense, you are dead. Now, for a corporate entity, Tarun, there is nothing more important than working capital. There's nothing more important than loans. There's nothing more important than going to the bank and your best terms. And, people have long relations with banks. Now, if you are able to, therefore, characterize you as black without hearing you at all, without telling you, in fact, a fraud circular doesn't require you to be told at any stage. Forget hearing you. It doesn't need to be told at all. You're just told that even after you're declared fraud circular, you may not be told. It may be sent internally to other banks. So that is the civil consequences doctrine, a very correct thing and rightly applied, but carried to its logical conclusion, which is why the judgment is commendable.
Okay. You brought out one very other important facet of this judgment, that policy decisions are not immune to judicial scrutiny. Could you explore that in the light of recent criticisms that court shouldn't get into policy, but then if policy blunders are done, which impacts industry, the court has no option. But I would rather have you explain the whole thing again in a broader context.
Again, Tarun, the argument comes from the RBI that, look, at the end of the day, it's a policy decision by the government. And policy decisions must be given, firstly, wide latitude. That means you will not interfere, even if it's erroneous. It's a policy. Second, they linked it to another concept, impliedly, natural justice is excluded. Now, on both of this, the court rightly negative, they said, it may be a policy decision. Of course, they don't have to give a finding, is it or not, but let's assume it's a policy decision. First point they made was, it does not mean Article 14 challenges don't lie. Don't think that by calling it or characterizing something as a policy decision, you are immunizing it from Article 14. They then said that obviously natural justice is part of Article 14. So if we find that Article 14, suppose you are proceeding in the master circular arbitrarily without even letting Tarun Nangia know that this proceeding is against him, then it will violate Article 14. And you can't just stop it saying, so look, it's a policy decision. The other thing I forgot to mention was that the implied exclusion doctrine was rather nicely dealt with by the court. You know, in Maneka Gandhi's case, there's this nice tripartite division. One is where the statute or the policy says affirmatively, specifically, that Tarun Nangia shall be heard. That presents no problem, neither for lawyers nor for judges, because he must be heard. If you don't hear him, tough luck, it's bad. The second category is where it says specifically that you shall not be heard. For example, atomic energy plants, national security, defense, specific exclusion. The middle category is the most difficult. It doesn't say affirmatively yes, it doesn't say affirmatively no. There is this nice phrase of Maneka Gandhi, decided, as you know, some 40, 50 years ago. The common law shall supply the omission of the statute, which means that the statute might have forgotten, but if there is no specific exclusion, you, the common law, will read into the law. And they then go on in this case to say, implied exclusion of natural justice must be very, very narrowly tailored. It must be the narrowest possible limits, which the combination of this means that, look, there is nothing here which suggests exclusion because the man is being punished. And as I said in between, blacklisting is another line of law, a very respectable lineage from Eurasian equipment, etc., which says blacklisting mandatorily always requires natural justice. Now they say, obviously, Mr. RBI, you don't call it blacklisting. But what is it if I treat Mr. Nangia as somebody who is not going to be dealt with, not going to be looked at, not going to be restructured? It is nothing but de facto blacklisting. And therefore, they married the doctrine of blacklisting with this concept and applied natural justice.
I want to ask you something about the one more point that you made, that now reasons for dismissal would have to be one which you explained in the last part of your answer. Could you discuss the impact of the judgment on the business community in India? Because many people in the past 5-7 years have suffered. Would they have any remedy now in the light of what has already happened, or we should consider it a closed case where whoever has suffered, and now henceforth, of course, anybody who's maybe going to be tagged as fraud, he will get a hearing. What about cases that just been admitted? Who will get relief?
This is a little technical, but let me give you the simple answers first, then the technical answers. First and foremost, in this very case, there was a batch of 3, 4, 5 cases. I don't remember exactly how many. So after laying down these principles, which we've just discussed, the court specifically set aside the orders, declaring Mr. A fraudulent account, Mr. B a fraudulent account, Mr. C a fraudulent account, etc., etc. They were set aside. And then they were remanded back to that committee, which will give natural justice to Mr. A, to Mr. B, to Mr. C, hear them, and then decide. So there's complete relief.
Okay.
Number two, by the way, it must be added that people tend to forget that reasons, which is not usually looked at as part of natural justice, is very much a part of natural justice. So giving you notice means they will dispose your representation of or hear you and then give a decision with reasons. Reasons make it very easy for you or me to find fault and say, look, this reason is completely unrelated to the case. It is wrong. So the requirement is not merely to give you notice by this judgment, but to give a reasoned dismissal if it's a dismissal. Now, the question you asked, that what happens to so one category actually got relief. That is what is called a inter partes category, namely those who had actually gone to the Supreme Court, High Court and then Supreme Court. Now, the second category is those whose cases in the whole of India, let's say 1 million cases, are yet to be decided. They have not yet been declared fraudulent accounts, but the banks are considering going down that path. Since the law of the land has been laid down by the Supreme Court judgment 2 days ago or 3 days ago, under Articles 141, 142, etc., these pending cases, which are not yet declared, the banks will have to follow this judgment. Stop wherever they are, give them notice, call them, hear them, and then pass reasoned orders this way or that way. That's another huge advance. So you're asking about impact. It will affect thousands of cases beneficially. Now, there is a third category where already somebody has been declared fraudulent, but that somebody has not gone to court. He hasn't challenged it. Well, obviously, the law is clear. Unless you challenge it, a judgment now will not automatically reopen the case of those who are not the members of that case. However, if some of them are within limitation, which are within 3 months, within some time, they're not very old, then they may file fresh cases. Otherwise, those cases are the only narrow class, which are, let me say, so-called older cases, which are closed and done. That will not be reopened by the judgment.
I'm going to stretch this argument a bit further and take a completely unrelated case, be it the case of Section 45 of PMLA, which was struck down, or be it the case of fraud circular where the government stepped into a policy decision. Do you think sometimes it is courts are unfairly criticized? Because if you look at these kind of judgments, courts bring a lot of relief to policy excesses or excesses when writing policy, which are maybe innocently committed. The policymakers themselves don't have the idea that what they are writing and comes in out form of a notification may have a very unintended impact or a consequence. Could you delve into this dilemma? Because the courts in a country like India, day after day have to get into policy issues which affect the citizens, maybe a businessman or otherwise, doesn't matter. But we're talking of citizens.
Kindly see, let me answer in many ways your question. The first point, kindly see the irony here. You pass a constitutional amendment in this country. Theoretically, it can be struck down as being violative of the basic structure. So a constitutional amendment can be unconstitutional if it is shown to be violative of basic structure. What a remarkable judicial review power we have. Take the second category, a statute. Every day, courts are striking down statutes as unconstitutional. Take a third level, delegated legislation, namely regulations or similar delegated legislation. They are struck down as ultra vires the statute or violative of the Constitution every day. Now, is it not ironical for you that you've got the Constitution itself can be unconstitutional? The statute can be unconstitutional. The delegated legislation can be unconstitutional. But a policy decision is so high that it gets suddenly immunized. That can't be. That's an inherent paradox. Number two, therefore, all that it means is that a policy decision is given more latitude. Latitude means that, and that depends on the nature of the policy decision. Suppose the policy decision is that in this country, you must give a little more fertilizer to X and Y categories of industries and a little less to Z and Z1 categories. Now, the court will not second guess that, look, Z and Z1 should not get less, but they should get equal to or more than X and Y. That's the meaning of latitude. But suppose the same policy said that both X and Y should get more fertilizer, but with no apparent difference between them, X should get 33% more than Y. It is still a policy decision, but we struck down as violative of Article 14, discriminatory. So this is the real meaning of policy decision. It does nothing more than give you a latitude for that part of it which is truly policy. Because courts don't decide the ought question, the normative question. They decide the positive questions. Thirdly, the court has rightly said that in effect the circular doesn't remain a policy decision, because the circular is actually going through a process. First, the JLF meets. As you know, the JLF is the Joint Lenders Forum. Then they may or may not declare you NPA. In all these cases, there is a prior declaration of NPA. That's a separate procedure. Then they go and see whether they can restructure. Sometimes IBC starts. Now, in between, they hold a meeting and say that we call it a fraud account. That's the issue in this case. This case is not about willful default. This case is not about NPA. This case is not about IBC. It was a separate procedure of declaring your fraud account altogether, and thereafter reporting it to the CBI or the authorities. So the court said, how is it possible that every other procedure has natural justice? They give you a notice, etc. But this is done in the interstices of your file. As a matter of fact, even the actual process of declaring you and the declaration before this judgment was not open to knowledge of the man who's being really sent to his death sentence. So I think policy has been overstated as a word. It has been rightly debunked and pierced, if I may say so, by the judgment. And it has been put in the right place because the value of fairness, transparency is much, much more. And remember, lastly, natural justice is a very wide concept in this country. It is something which is fair play in action. People say all the time, they tell you, look, even if Mr. Nangia had heard Mr. Singhvi, his decision would be the same. So what's the point of Nangia wasting time hearing Singhvi? Natural justice doesn't work on that presumption. It says that we believe in the milk of human kindness, in the goodness of humanity, and we are sure that if Mr. Singhvi is given a fair chance of being heard by Mr. Nangia, there is a possibility that Mr. Nangia's view may change. And that is the essence of natural justice.
Thank you for so beautifully putting in perspective all these things. I want to ask you something. See, you have the unique position of being a third-time parliamentarian who, in a sense, authors laws in parliament. They go under your scrutiny when you're part of various committees. Deliberations are held. Why do bad laws get written and generate so much of unnecessary cases in court? It clogs the court. Is it because there are less lawyers in parliament? We did a show on this issue. We need more lawyers, so good laws.
I'm not sure to what extent you can correlate automatically more lawyers and better laws or less lawyers and worse laws. That correlation may be false. But I think this is a very much larger issue which merits a separate discussion, but there is no doubt that the quality of lawmaking in terms of text, texture, precision, depth, the way in which it is written, syntax, language, grammar, there is absolutely no doubt that it has gone down humongously. Now, there is a combination of reasons. It's no one reason. But the combination is a deadly cocktail. There are poorer draftspeople. You know, the old secretaries, joint secretaries, additional secretaries and undersecretaries of the legislative wing, would put a English professor to shame, would put a law professor to shame. They were very learned men, and there's different times. Today, I don't think we have that quality. That's reason number one. Number two, you see the divisiveness in parliament. Where do you find in that piercing intellectual analytical approaches, genuine discussion where I point out the comma and full stop, and Nangia on the other side gets up and says, no, this is the other. For that, you require a positivity, a lack of a trust deficit, a convergence of views. Number three, I have been fortunate in being the chairman of 3 parliamentary committees, law, home, and now I'm currently the commerce one. I've always believed that parliament at work is parliament at committee, or parliament at committee is parliament at work. Solid consensual work is done there, which you don't see, which is behind closed doors, but is far superior to the convergence and consensus you can see in the House. Now, unfortunately, that is also getting less and less. That's the third point. Today, referrals are fewer. For the last 7, 8 years, the number of cases referred to standing committees has diminished considerably. Secondly, within committees, and I hate to say this, but I'm speaking from my own experience, divisiveness has increased. People are frequently appointed to the committee only for their value in creating a certain divisiveness, an altercation, a lack of convergence. I don't think any of this is good. Today, I am in party X, you're in party Y. That's not the point. The whole process suffers. So this is something we have to sit down seriously and think out, that at least allow parliamentary committees to do solid work, refer more and more laws to them, get their reports, because that gives you a focus, which is not available in the larger house. It's too much of sermonizing to say, oh, let the house function properly, let there be no disruption. That will take ages to happen, and that's a larger issue. But at least in committee, you can get precision and elegance and accuracy of a higher degree. Not as much as was there in the old days, but certainly of a higher degree than there's now.
Yes, yes. So as you would have seen, viewers, on Saturdays with Singhvi, you get a lot more than just legal takedown of issues or analysis. You also get parliamentary perspective. We have the benefit of Dr. Singhvi being now for the third term in Parliament. It was a pleasure to have you today on the show, as usual. And the viewers of Saturdays with Singhvi got their dose of intellectual inputs, not from courts, but also from Parliament where laws are made. Appreciate you joining us. Thank you so very much.
Thank you. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.